Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I have the day off of work.
say what?
I have the day off of work. I can.
I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement, including raising nonsensical challenges and attempting to apply commercial law to criminal prosecution or equitable law.
No, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it.
121047. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a Ferretta hearing.
It is Ferretta. Mr. Aligretti wants to represent himself. Sir, did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Aligretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
and you will have counsel.
talking.
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that, Your Honor.
You are accepting it, sir. You know what direct contempt of court is, sir?
I wanted to put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record. Understand that, sir?
Yes.
What's your address?
7021 Square, Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago. Officer Ball, can you give him this? Sure. In that, I wanted to make sure that you were explicitly warned that, well, firstly, I'll consider this conduct during the Ferretta hearing as evidence of an inability or unwillingness to abide by the rules of procedure, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time you're a lawyer's filing things, because they're responsible for anything that would come to this court. Do you understand? So any motion
I do not
that they would
understand.
file. What did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I had some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer, though.
I just appointed a lawyer for you.
But I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sir, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay, so I have time that I work on cases. Everything was pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your
why?
Honor, but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in equity, Your Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter.
Okay, let's go through the charges again. I had an initial hearing with you. Let me see when I had the initial hearing. Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all three charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. Do you not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28th, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be September 28th of 2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you.
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Then why
I'm just
if you're just going to give me an
trying to
attorney?
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah, do not.
I'm required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand you
want- I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No. I already appointed a court-appointed attorney for you because you can't get through the Feretta hearing. You understand why you can't get through the Feretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in propria persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear. Because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body and I'm a living human
What does it
being.
mean, sir?
Are you here to practice court? I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
trying to bring
I'm using the law in equity.
using sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
and
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
What's your statement?
Why is that so hard to?
Because the first part of your statement, this is a Feretta hearing. I'm here for a Feretta hearing. I've already denied your Feretta rights based on the very first words that came out of your mouth, which was that you're not willing to subject yourself to the jurisdiction of the court. If you're not willing to subject yourself to the jurisdiction of the court, you're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. So I've appointed counsel for you. I was going through the charges in count one, but I needed to find something here. I took some notes the other day related to your case, and I wanted to make sure that we had that as well. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me, what do you not understand?
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Aligretti, is find that you've unduly delayed these proceedings.
All I want to
Find you in direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor, I
contempt.
have a job.
Please take Mr. Aligretti into custody. We'll try again tomorrow, sir. We'll be adjourned in F2 10947. And I'll open a new case on the contempt proceeding as required by rule.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes,
Some more time?
Yes.
Yeah. Guys, he was just sitting on that other date.
Okay.
All right. We'll see you back here on the 29th of May, sir.
Thank you.
Prince Pugh, stay, would you please start a record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pugh. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary German.
I think it's an F6, though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Purple?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pugh since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pugh has filed, and I guess I'm looking to get some clarification from the court and Mr. Pugh as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pugh is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if in fact that is what he wants and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pugh. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay?
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pugh on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes,
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of American Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Mr. Pugh, I'm going to set your case over for a few weeks to June the 12th at 8:30. I'll have you back June the 12th at 8:30, and we'll see you back here then.
I object.
Noted. This denied that you want to subpoena Dwayne "The Rock" Johnson. I don't believe he's going to have anything relevant to talk about at the trial. We'll make sure this gets uploaded as well. I need that stamped as well. That needs to go in there too. Wasted a stamp on that one. Okay. Good?
Oh, yeah.
Okay.
Well, how's come last time, I tried to ask them if I could turn something into them through the correctional office. They told me they just fed me a story that they gotta ask somebody if they can or can't do that, and they tried to act like I wasn't allowed to do that.
I don't know. I generally believe that when somebody tells me something like that, that there is some sort of administrative process they have to go through to actually do the thing that you're trying to get done because they're trying to protect and keep people safe and all this.
So what if I try to get them to do what you just asked me to, and they tell me no once again?
Well, I think they're going to understand that I asked you to,
Well,
right?
they didn't understand last time.
Did you invoke the power of Judge Fish and say, Judge Fish told me to ask you to do this?
Yeah, I told them that. And
Okay.
they wouldn't allow
Mr.
me.
Hammer, you want to approach and police this up?
Yes, Your Honor.
Yeah, I'm staying right here. We're adjourned, but I got another hearing, so you're free to go. Thank you, sir. Yeah. Yeah, you can take as long as you need. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that
Yes.
we don't permit what's called hybrid representation. Okay, so you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes,
You do understand that?
yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here.
Okay.
Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so
Yes.
we'll upload them into the file and strike them from the record, as I mentioned. Let's get a trial on the calendar. Mr. Prosecutor, how many days you need to try this case?
Judge, I believe 2.
And let me say something. Because I'm not being represented and I'm not, my evidence is not being presented like it's supposed to be. Yeah, because you're not helping me. Would I be able to say something? Okay.
All set trial by jury on August 18th and 19th. So Ms. Butler, I set you over for a jury trial on August 18th and 19th, 2026. If you fail to appear for your jury trial, I'll hold it in your absence and you can be convicted even if you're not present. You understand that?
I comprehend.
We're adjourned.
Your Honor, before we adjourn,
Can you grab the mic?
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently, it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Ferretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay, I mean, I can do that Ferretta hearing, but I'll let Mr. Pribble go for the day and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Ferretta hearing with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay, would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you a whole new one.
spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Oh, go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So, for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Ferretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty of 2 level 6 felonies? So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills in, an attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend that.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations,
Mhm.
findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes,
different things like this. And then
Yes.
there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
well, I had did some research on my case, and I noticed that I had in a
Oh,
high,
ma'am, that's not the question I
no,
asked.
no,
I think you misunderstood the question.
it's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand that?
Yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
it should be April 16th or 15th.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Mhm. Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a pseudo legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it, and I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brand new violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Feretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court
If
proceeding.
you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
guys
filings.
This is a bank. This is a bank. I understand how the
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes, it
bank in any way whatsoever.
I
So-
took it- hold on, let me finish.
No. I'm not going to let you finish that
Okay.
particular
Like
statement.
I said, I want to
Because I
conference.
just
Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes. Yes.
You will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes. It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So you
telling
will
me
not
to
strike
follow
it?
the rules.
You won't strike it down, or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay,
You realize
But-
that?
but let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something, and I am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor loss of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office give notice of its observations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon it and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No,
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
no, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.